Today, we're going to cover the third in the series, Regulation and the Use of AI. So I'm going to cover today a brief introduction and then talk through the EOPA opinion related to AI and the AI Act. And then I'll conclude with some thoughts on what firms should be thinking about at the moment. Now, this topic is very broad, as you can imagine, and there was a lot of content that I could have included, but it would probably take all afternoon, and we don't have that time. And there probably isn't an appetite for spending a whole afternoon on regulation. So I expect the presentation to take about 40 to 45 minutes, which leaves about 10 minutes at the end for Q&A. And as Fiona explained, we will take questions at the end, but do add them to the Q&A as you think of them as we go through the presentation. Finally, some of the slides are a little bit busy, but I wanted you to be able to use the slides as a resource after the presentation. And I have included a couple of more detailed slides in an appendix, and then you can use those when you get the slides and when the slides are shared with you. But there is one important point, and I want to just note, please don't take the slides as a replacement for reading the relevant documents, as in this session, it's just not possible to cover all of the detail. But hopefully having this introduction and overview, it will make the documents easier to read when you do get to them. So just moving on now to the introduction. So on this slide, I just wanted to thought it might be helpful just to go through and include a reminder of the different terms that you might come across in the broad category of AI. Now, this slide is not intended to be a tutorial on AI, as I would not be the best person to do that, but rather it's just a reminder of the terminology that you might hear as we then consider the relevant regulation. So AI spans a very broad spectrum, from very simple AI systems to very complex Gen AI systems that can create content. Now, I will completely admit to plagiarizing here. I've taken the text in this diagram from the IBM webpage, and I've given you a link to that article there. But in fairness, you can find similar descriptions and graphics if you undertake your own research. AI has been going around for quite a while. It started around in the 1950s. Machine learning was emerged in the 1980s. Deep learning in the 2010s, and Gen AI in the 2020s. So what exactly are they? They all sit within the broad scope of AI. Machine learning then involves creating models by training an algorithm to make predictions or decisions based on data. And there are a number of different types and terms that you might hear, such as linear regression, decision trees, random forest, neural networks. And deep learning then is a subset of machine learning that uses multi-layered neural networks called deep neural networks that more closely simulate the complex decision-making of the human brain. The multiple layers enable unsupervised learning, and they're well suited to tasks involving fast, accurate identification of complex patterns and relationships in large amounts of data. Generative AI, often called Gen AI, refers to deep learning models that can create complex original content, such as long-form text, high-quality images, realistic video or audio, and more, in response to a user's prompt. And finally, then you have the concept of an AI agent, which is an autonomous AI program which can perform tasks on behalf of a user or another AI system without human intervention. And you might have come across the term agentic AI, which is essentially a system of multiple AI agents where the efforts are coordinated to accomplish a more complex task or a greater goal than any single agent in the system could accomplish. So hopefully that gives you a little bit of background to the different terms that you may hear in the world of AI and to which the regulation that we're going to talk about today applies. Again, I thought it might be helpful just to introduce this session by just stepping back to kind of think a little bit about what is the purpose of regulation. So the key objectives of regulation are to protect the end user, and in our case, that would be insurance consumers, and to protect the financial soundness of the firm. And so from an AI perspective, regulation supports the responsible and ethical use of AI and data in order to support innovation and consumer confidence. So the use of AI in insurance is already covered by existing regulation, as the existing regulation is technology agnostic. The regulation is already in place, and key elements are set out here on the left-hand side of the slide. And they include Solvency II, the Insurance Distribution Directive IDD, DORA, Consumer Protection Code, and GDPR. The EU has introduced new legislation for the use of AI for all sectors, including the financial sector, namely the AI Act, in order to set out requirements for the appropriate use of AI across all industries. It is specifically focused on the protection of fundamental rights. And some key topics within the AI Act are set out in the right-hand side of the slide. So it includes definitions, the scope of application, risk classification, requirements, timelines, innovation, and governance. And we'll cover some of them later. Now, as you can imagine and kind of probably see, there's clearly a material overlap between existing regulations and the AI Act for all financial services, which makes the AI Act implementation more manageable for insurers than indeed for some other industries. And indeed, the AI Act itself recognises that some requirements of the AI Act are already covered by financial services regulation. However, it does still have some additional requirements that insurers will have to incorporate into their overall management of AI use. And just to note that the Commission is expected to publish guidelines shortly setting out the overlap between the AI Act and existing sectoral regulations. And again, I would just like to repeat again at this point that, again, I could run a number of sessions on each one of those topics. But as the current legislation already applies, I'm going to try and cover a little bit more detail on the EIOPA opinion, and we'll pick out some of the key points on the AI Act. And again, just to note that this presentation doesn't replace reading the actual regulation itself. So we're going to start today with the EIOPA opinion. So EIOPA has recognised that the use of AI in insurance is already covered by existing regulation. And in August 2025, it published an opinion on AI governance and risk management. Now, the objective of the opinion is to provide further clarity on the main principles and requirements in the insurance sector legislation that should be considered in relation to those AI systems that are not considered prohibited practices or high risk under the AI Act, although it does recognise that the sectoral legislation applies to all AI systems. Some key points in relation to the opinion, as set out in the slide, are that the opinion follows a principle-based approach. It does not set any new requirements, but rather provides guidance on how to interpret the various provisions of the existing insurance sector legislation in the context of AI systems that were either non-existent or not widely used when the legislation was approved. And to ensure consistency at EU level, the opinion is based on the definition of AI system as defined in the AI Act. So over the next couple of slides, I'm going to cover some of the detail in relation to the opinion. So the two main topics covered by the opinion are risk-based approach and proportionality, and secondly, the risk management system. Both of these have the same legislative references, and in each of the slides going forward, I will include the legislative references that relate to the particular topic. And I didn't actually go to the trouble of looking at all of those references. These are the references set out in the opinion itself. And before we go on again, there are 2 points that I would like to just note in case I don't mention them throughout the presentation in respect of the opinion. There are 2 recurring themes in the opinion. The first is proportionality, and that all of the requirements should be applied in a proportionate manner. And the second one is that all of the requirements apply throughout the life cycle of the AI system. So there are 2 recurring themes you will see in the opinion when you read it. So under the first box of this slide, risk-based approach and proportionality, the assessment of risk should be adequate and proportionate to the risks of the specific use and conducted in a manner that is proportionate to the potential impact of the specific AI system on both customers and the undertakings themselves. The opinion sets out some helpful criteria to consider in the impact assessment, and undertakings should also assess prudential considerations and operational risk. Having undertaken the impact assessment, undertakings should develop a set of proportionate measures to ensure responsible use of AI. And recognising potential trade-offs between explainability and accuracy of some AI systems, consideration should be given to complementary risk management measures such as data governance and human oversight. The next box covers the risk management system, and the opinion sets out the areas for which risk-based and proportionate governance and risk management systems should be developed, and I cover them on the next few slides, and they are fairness and ethics, data governance, documentation and record keeping, transparency and explainability, human oversight, accuracy, robustness, and cybersecurity. The opinion notes that the responsible use of AI is not achieved by a standalone measure, but by a combination of different measures. And undertakings need to define and document the approach to the use of AI systems across the organisation, particularly throughout the life cycle of an AI system, and this approach should be regularly reviewed. The approach to AI systems should also include frameworks where the roles and responsibilities of different staff and the interplay between those roles are set out. Undertakings are ultimately responsible for AI systems that they use, regardless of whether they are developed in-house or with third parties. However, third parties do have a role to play, and undertakings should obtain adequate information and assurances from third parties about characteristics and capabilities, training data, limitations, etc. And if that's challenging due to intellectual rights, the use of complementary approaches such as contract clauses, external audits should be undertaken to mitigate the risk. So to the first of the elements of risk management system, which I'm going to go through in the next couple of slides. So the regulatory references are set out again on each of these slides. And just to talk a little bit then about the fairness and ethics. So undertakings should adopt a customer-centric approach to the use of AI systems through their entire life cycle and across the value chain so that customers are treated fairly and according to their best interest. And this includes developing a corporate culture appropriately documented that includes ethics and fairness guidance and training for relevant staff. Data governance policies include making reasonable efforts to remove biases in the data, and the outputs should be meaningfully explainable to identify and mitigate potential bias. The outcomes of the AI systems should be regularly monitored and audited where appropriate, with the use of fairness and non-discrimination metrics. And the opinion includes some examples of those metrics in an appendix. And finally, adequate redress mechanisms should be put in place. So in respect of data governance, undertakings should implement a data governance policy, and that policy should comply with relevant insurance and data protection legislation. The data used to train and test the AI system should be complete, that is, with sufficient historical information. It should be accurate, as in there should be no material errors, and appropriate, as in it should be consistent with the purposes for which it is to be used. Any limitations should be documented. Again, sound data governance should apply across the life cycle of the AI system, and the same data quality standards should apply to any external data used. In respect of documentation and record keeping, undertakings should keep appropriate records of the training and testing data and the modelling techniques in order to enable their reproducibility and traceability. The opinion provides an example of the types of records that should be kept, and I've set out some of the examples here, such as reasons for using AI, data collection and preparation, and model performance. And then on to transparency and explainability. And just to note that the delegated regulations that are referenced in the opinion relate to the delegated regulations for Solvency II and for the IDD. So from a transparency and explainability perspective, undertakings should ensure that the outcomes of AI systems can be meaningfully explained. Different approaches can be used, such as using explainable AI instead of a more black box AI, or using complex AI systems only for the purpose of challenging and fine-tuning traditional mathematical models. The explanations should be adapted to the specific use of AI. For certain uses, if the complexity hinders the full transparency and explainability, undertakings should put in place, where necessary, complementary risk management measures such as stronger guardrails and increased human oversight. Undertakings should comprehensively secure and test, before release and on an ongoing basis, those uses of AI systems that could have a high impact on customers or the solvency of the undertaking. The explanations should be adapted to the needs of different recipient stakeholders. So, for example, undertakings should be able to provide to competent authorities and auditors a comprehensive explanation about the functioning of the AI system. For customers, in addition to being informed that they are interacting with an AI system, upon a customer's request, the influence of the AI system on the decision that has a material impact on them should be clarified using clear language. Insurance intermediaries should also be informed by insurance undertakings when a decision is made on the basis of an AI system so that they can comply with their legal obligations. Human oversight. Undertakings should put in place effective internal control systems during the entire life cycle of the AI system. Roles and responsibilities should be defined in the policy document, including escalation procedures involving relevant staff in the necessary steps of an AI system lifecycle. The opinion sets out points for consideration for the board, compliance and audit functions, the data protection officer, and the actuarial function. It suggests possible organizational arrangements, but recognizes that firms can organize in whatever way they feel appropriate. It sets out that sufficient training should be provided, and human oversight should support the identification and mitigation of potential biases. And finally, to accuracy, robustness, and cybersecurity. Undertakings should define the levels of accuracy, robustness, and cybersecurity of AI systems. The AI system should perform consistently in those respects throughout their life cycle, regardless of whether they've been developed in-house or purchased from third-party providers. The undertaking should use metrics, including fairness metrics, to measure the performance. For example, accuracy, recall, etc., adapted to the AI system in question. The metrics should support ongoing monitoring and enable the timely identification and remediation of issues such as model drift or data degradation. When testing an AI system, undertakings should assess potential connections to other AI systems via APIs, application programming interfaces, since this could impact the overall security and performance of an AI system. AI systems should be resilient against attempts by unauthorized third parties to alter their use, outputs, or performance by exploiting system vulnerabilities. So there should be adequate and up-to-date IT infrastructure, as well as fallback plans to ensure ICT business continuity. So that's all that I'm going to cover today on the EIOPA opinion. It essentially does cover most of the detail within that opinion. It's quite a short document. It's easy to read, so I would just encourage you all to read it. So now moving on to the AI Act. So the AI Act was came into force on the 2nd of August 2024. The Department of Enterprise, Tourism and Employment, DETI, is the government department tasked with the implementation of the AI Act in Ireland. So I have included a link to their page on AI, and it has some useful information, but it also has links to another short AI course, which I think is a useful educational resource. It's a free course provided by CEDAR, and the link will be on that page. The objective of the AI Act is to foster trustworthy AI in Europe. It is to promote the uptake of human-centric and trustworthy AI while ensuring protection of health, safety, fundamental rights, the rule of law, and environmental protection, and to protect against the harmful effects of AI systems. It also has an objective to support innovation. Now, before I get into setting out some of the requirements of the AI Act, and I know it's quite a long document, I would encourage you, though, to read the recital in addition to the AI Act itself, because the recital does provide some very helpful context for the actual articles within the Act itself. And for those of you who may not be familiar with regulation, the recital is the commentary at the beginning of the Act. Finally, as I've said, the DETI is responsible for the implementation of the AI Act in Ireland, and it has just recently published its general scheme of the Regulation Artificial Intelligence Bill 2026. Sorry, that's a long name, which outlines the heads of the general scheme, and that's necessary for the full implementation of the AI Act. Now, it does include setting out the names of the responsible bodies in Ireland for various governance roles. It also talks about setting up the AI office in Ireland. It also talks about penalties. So generally everything that needs to be organised in order for the AI Act to be implemented in Ireland. So onto the AI Act itself. I show this diagram at the beginning of the slides, and I just have circled here the elements of the AI Act that I'm going to cover today. So I'm going to cover definitions, key definitions, not all definitions, scope, risk classification, the requirements and the timelines. I'm not today going to cover innovation provisions related to sandboxes or the overall governance of AI, such as the role of the AI office. I tried to focus today on what might be most important to you in terms of the requirements that you might have to implement. So, starting with some key definitions. The AI Act sets out a definition of an AI system, which is there on the left-hand side of the slide. And it recognised that the definition should be closely aligned with the work of international organisations working on AI in order to ensure legal certainty and to facilitate international convergence and wide acceptance, while also providing flexibility to accommodate the rapid technological developments. It was also recognised that the definition of an AI system needs to be based on key characteristics that distinguish it from simpler systems. And so the definition is as set out in the slide. An AI system is a machine-based system that is designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. The Commission has published further guidance on the definition of an AI system within the AI Act in February 2025, and I've included a link to those guidelines on the slides. This slide also sets out the definitions or the scope of the different roles which are termed operators within the AI Act. So I've set out there the role of provider, deployer, importer, distributor, and authorised representative. And all these roles are defined within the AI Act, and we'll cover a couple of them in the later slides. So in terms of what is in scope of the AI Act, we have providers and deployers of AI systems located in the EU. Providers and deployers in third country, but where the output of the AI system is used in the EU. Importers and distributors of AI systems. Product manufacturers putting an AI system together with their product and under their own name or trademark. Authorized representative of providers which are not established in the EU, and affected persons that are located in the EU. Moving on now to risk classification. So the AI Act sets out to apply a risk-based approach in setting the requirements for AI systems, and it has introduced a classification system of AI systems to achieve that. Starting first with prohibited practices. I think it's self-explanatory. It has identified certain AI practices that are considered particularly harmful and abusive and are therefore prohibited. The AI Act identifies AI systems which pose a high risk to fundamental rights. The systems that are relevant for insurers are set out in Annex 3, and I'll cover them on the next slide. The AI Act recognises that there may be specific cases where AI systems referred to in predefined areas specified in the Act do not lead to significant harm because they do not materially influence the decision-making or they do not harm those interests substantially. And so it sets out some limited criteria for that specific high-risk AI system to be exempt from the requirements of the AI Act. The Commission is expected to publish further guidance on high-risk AI systems in Q1 2026. However, I would like to take the opportunity here to highlight that if an AI system is not classified as high risk under the AI Act, that does not mean that it is not a high risk system. We understand that firms use a broad set of additional criteria for the assessment of risk of an AI system. So, for example, firms may consider prudential risk, customer risk, operational risk, or reputational risk. And so firms should undertake an appropriate risk assessment of all AI systems in use in accordance with existing risk management regulation. We then have general purpose AI models. These are AI models including where such AI model is trained with a large amount of data using self-supervision at scale that displays significant generality and is capable of competently performing a wide range of distinct tasks, regardless of the way the model is placed on the market, and that can be integrated into a variety of downstream systems or applications, except for AI models that are used for research, development, or prototyping activities before they are placed on the market. And finally, there are other AI systems where the AI Act has some specific transparency requirements. And these are AI systems which are intended to interact directly with natural persons, that are generating synthetic audio, image, video, or text content, that generate or manipulate image, audio, or video content constituting a deep fake, that generate or manipulate text which is published with the purpose of informing the public on matters of public interest, and emotion recognition or biometric categorization systems. So this slide sets out the high-risk AI systems which are set out in Annex 3 of the Act. Now, I have paraphrased the systems, the text in some cases, or just use the heading. So please do refer to Annex 3 yourself. I've highlighted in a lighter blue the AI systems that might be most relevant to insurers, but of course some of them would also be relevant to other industries as well. So biometrics, a possible use for insurers is the use of AI systems for emotion recognition, for example, in customer service call centers. Employment, This includes the use of AI systems in recruitment and in employee management, in making decisions affecting the terms of work-related relationships, the promotion or termination of work-related contractual relationships, allocation of tasks based on individual behaviour or personal traits or characteristics, or to monitor and evaluate the performance and behaviour of persons. The next two are more financial services related. The first one is the evaluation of creditworthiness or the establishment of a credit score, and there may be some insurance products where a person's credit score may be relevant. And then finally, there is an insurance-specific high-risk AI system set out in Annex 3, and that is the risk assessment and pricing in relation to natural persons in relation to life and health insurance. So for those high-risk AI systems, the AI Act sets out some requirements. So these are mandatory requirements with which high-risk AI systems should comply in order to mitigate the risks, to ensure a high level of trustworthiness, taking into account their intended purpose and context of use. It is the providers of high-risk AI systems that are required to ensure that their AI systems comply with these requirements. So a couple of points to highlight. Firstly, on the risk management system, providers are required to consider the technical knowledge, experience, education, training to be expected by the deployer and the presumable context in which the system is intended to be used. In relation to risk management, this is where there's an overlap between a recognition of the AI Act of the fact that financial services firms may already have a risk management system in place in line with the sectoral legislation, and therefore they can use that risk management requirements to cover the requirements in relation to the AI Act high-risk systems risk management requirements. The data and the data governance requirements cover training data and the intended purpose of use and bias. The technical documentation should cover at a minimum the requirements in Annex 4 of the AI Act, which cover both a general description of the system, as well as a detailed description of the AI system and of the process for its development. The record-keeping requirements cover the automatic recording of events and the traceability and functionality of a high-risk AI system. The transparency and provision of information to deployers covers the level of transparency required and the information to be provided. And human oversight is to ensure protection of fundamental rights, and the requirements include specification of measures to ensure those tasked with human oversight can carry out their responsibility. And accuracy, robustness, and cybersecurity require, as it says on the pack. So this slide sets out the different operators, and I have included a definition for each of the different operators listed here, and I'll just talk through a couple of the key responsibilities. So a provider is essentially the person that develops the AI system and puts it in the market, places it on the market, or puts it into service. A key responsibility of the provider is to undertake a compliance assessment to ensure that AI systems are compliant with the requirements that I've just highlighted in the previous slide, and to certify that requirement in line with the certification requirements of the AI Act. Another key responsibility of the provider is to register the AI system in line with the Act. Providers are required to demonstrate the conformity assessment to competent authorities in response to a reasonable request, and other responsibilities include clearly identifying contact details, retention of documentation and automated event logs, and taking any corrective actions as all set out in the Act. Deployer is essentially a person who's using an AI system, although users of AI for personal purposes are exempt from the requirements of the Act, which you might be pleased to know. A key responsibility of the deployer is to ensure that it is operationally ready to use the AI systems by taking the appropriate technical and organizational measures to ensure they use such a system in accordance with the instructions for use accompanying the systems, including assigning human oversight to natural persons who have the necessary competence, training, and authority, as well as necessary support. Deployers are required to monitor the operation of the high-risk AI system on the basis of instructions for use, with additional responsibilities set out in the Act. There are also requirements related to data and cooperation with relevant competent authorities. Finally, there are some specific responsibilities for specific uses. For deployers of high-risk AI systems related to the creditworthiness and the risk assessment and pricing for life and health, they are required to perform an assessment of the impact on fundamental rights that use of such systems may produce. And the Act sets out the requirements for that fundamental rights assessment, which applies to the first use, and you also need to involve the relevant competent authority. For deployers who are employers who deploy a workplace system, there are specific requirements. And Annex 3 systems making or assisting decisions related to a natural person, they need to inform the natural person. For importers and distributors, there are some common obligations such as the verification of conformity, risk assessment, safety measures, requests for information and cooperation with relevant competent authorities. Importers are also required to have transparency over their role and document retention, and distributors are required to continue post-market risk assessment. So as I said earlier, there are some AI systems for which there are specific transparency obligations. So in relation to providers shall ensure that AI systems intended to interact directly with a person are designed and developed in such a way that the person concerned is informed that they are interacting with an AI system, unless it is obvious to reasonably well-informed persons. Providers of AI systems generating synthetic audio, image, video, or text content shall ensure that the outputs are marked as AI generated or manipulated. For deployers of emotion, recognition, or biometric categorization systems shall inform the person exposed to the operation of the system and prove that the personal data is used in accordance with relevant regulations. Deployers of an AI system that generates or manipulates image, audio, or video content constituting a deep fake shall disclose that the content has been AI generated or manipulated. Deployers of an AI system that generates or manipulates text which is published for the purpose of informing the public on matters of public interest shall disclose that it is AI generated or manipulated. Information shall be presented to persons in a clear and distinguishable manner, and the latest at the first time of the first interaction or exposure. And the AI Office, which is responsible, the overall commission, it's within the commission and is the overall EU body responsible for the AI Act implementation. It shall encourage and facilitate the drawing up of codes of practice at EU level to facilitate the implementation of these requirements. For general purpose AI models, in addition to the definition of a general purpose AI model, a GPAI, there is also a specific classification of a general purpose model with systemic risk, which is essentially a GPAI with high impact capabilities to which some additional requirements may apply. So for providers of GPAIs, the requirements are set out in the slide above. There's a requirement to draw up and keep up to date technical information, including its training and testing process, and the minimum level of information is set out in Annex 11 of the Act. To draw up, keep up to date, and make available information and documentation to providers of AI systems who intend to integrate the GPAI into their AI systems, and to enable the providers to have a good understanding of the capabilities and limitations of the GPAI in order to comply with their own requirements. To put in place a policy to comply with copyright law, and to draw up and make publicly available sufficiently detailed summary about the content used for the training of the GPAI, again according to a template drawn up by the AI Office. There is a requirement for an authorised representative where the GPAI provider is in a third country. And finally, there are requirements for GPAIs with systemic risk. The AI Office will encourage the development of codes of practice for compliance with the requirements, and the supervision of GPAIs fall to the AI Office, and the related powers of the Commission are set out there on the right-hand side of the slide. So the final slide on the AI Act is in relation to the timeline. So, as I said, the Act came into force already, but it applies from the 2nd of August 2026 with the following exceptions. So Member States had until the 2nd of November 2024 to identify public bodies which supervise or enforce fundamental rights in relation to the use of Annex 3 high-risk AI systems and make that list publicly available. And I've included on the slide a link to the DETI's published list of public bodies for Ireland. And they include the Data Protection Commission and the Financial Services and Pensions Ombudsman. The obligations related to prohibited practices and AI literacy apply from the 2nd of February 2025. The prohibited practices are listed in Article 5, and they essentially, the requirement is pretty self-explanatory: don't undertake those practices. And the AI literacy requirement is set out in Article 4, and it essentially requires providers and employers to ensure that their staff have the appropriate level of skill. However, as part of the Commission's overall simplification agenda, it published a digital omnibus package in November 2025, which included some provisions in relation to the AI Act. One of these was to relax the Article 5 requirement and make it a requirement for the Commission and Member States to promote AI literacy rather than a requirement on providers and employers. Note that the published digital omnibus package, it's at the moment still a Commission proposal, and it will need to be agreed by Council and Parliament, and so it may change. Requirements related to general purpose AI models, notifying authorities and notified bodies, governance, including designation of competent authorities and penalties, came into force on the 2nd of August 2025. And then finally, from the 2nd of August 2027, the requirements in relation to Annex 1 high-risk systems come into force. Another amendment, though, proposed in the omnibus is to defer the requirements in relation to the Annex 3 high-risk AI systems, some of which are relevant for financial services firms, until 6 months after the relevant guidance has been published, but no later than the 2nd of December 2027. And we understand that there's some suggestion that they will consider just deferring the date to the 2nd of December 2027 without the kind of rolling date, but we'll wait and see what the Council and the Parliament do, how this whole omnibus changes over the next couple of months. So that's it on the AI Act, and I'm just going to close now with some concluding remarks. So on this slide, I've set out just some thoughts to describe the questions that you might want to be able to answer in order to undertake your own assessment of the governance and risk management frameworks in place to ensure the responsible and ethical use of AI. And I would think that these are considerations that a board could reasonably ask. So firstly, describe your AI strategy and how you determine your use of AI. And some questions that you might want to think about in answering that for yourself might be: describe your objective for the use of AI and how you assess whether specific use cases fit within that objective. Describe the principles or criteria that you've established that govern when you use an AI system. Describe the process you have in place that ensures all AI systems sit within the objective and it is appropriately achieved. And describe the metrics you have established for monitoring that process. Another key question would be: describe the governance framework around the use of AI. And again, some questions that might help you with that one are to be able to describe how the use of AI is governed within the organisation, from individuals all the way to the board, including how decisions are made, describe how you ensure you have a complete picture of all use of AI within the organization. And finally, describe how the risks related to the use of AI are managed. So how are the risks identified for each system? How are those risks managed? And how do you balance the risks and the benefits? And how are the risks monitored and managed throughout the life cycle of the AI system? And then finally, how is the use of third-party systems managed from the purchasing process throughout the full cycle? So hopefully that gives you a good overview of the regulation that's applicable to the use of AI, and to just remind you that the existing regulation already sets out a lot of the governance and risk management requirements, and there's a significant overlap with those for the AI Act. And of course, the use of AI is materially broader than the specific use cases that are set out in the AI Act. So the existing regulation is probably much more relevant to your use of AI than the specific additional requirements of the AI Act when they come into force. So very happy to take questions now, and I'll stop sharing, but happy to go back to the slides if somebody has a specific question on one. Thank you.
Thanks very much, Anne. Very comprehensive. So we'll move now into the Q&A segment. There are a few questions here already. So Anne, I'll just start with the first one that came in, and this is from Brian. This says, obviously the AI Act only sets out the minimum standards, not the ideal standards. What are your thoughts on what a gold standard AI framework in firms should look like?
I'm very pleased that somebody's looking for the gold standard. I think at the end of the day, the points that I've set out in the last slide are very, very good pointers to what firms should be considering in terms of establishing their AI, an appropriate framework for AI. I think it should be risk-based, yes, but I think in order to assess the risk, you do have to understand all use of AI within the firm. You need to ensure that everybody's use of AI is very well managed, and to then make sure that staff are competent and sufficiently skilled in order to be able to identify the risks and know how they are managing the risks associated with the system. So I think if you start with the list of questions or suggested considerations that I put on the last slide, I think that will provide good direction to establishing an effective governance and risk management framework within the firm.
Thanks, Anne. Moving on to the next question then. This is from Michael. This is a bit of a difficult one, I think. As some social media platforms now heavily employing AI, is it fair to say that these platforms are contravening, if not the letter of the Act, then certainly the objective of protecting the consumer?
Yeah, I have to say I'm not going to be able to answer that question, because having not looked at it, etc., I don't think I'd be in a position to answer that question. But if they are within the scope of the AI Act, or if they should certainly be complying with the requirements of the AI Act when those requirements come into effect.
Thanks, Anne. Question now from Camilla. Is a data governance officer mandated for insurers, or is it best practice?
I'm going to have to come back to you on that one, because I'm not, or maybe somebody else in the chat might be aware of, I'm not an expert on the GDPR, which would set out the requirements for what data, oh, sorry, you're talking about data governance, not data protection.
Yeah.
The AI Act or the current regulation doesn't specify necessarily how the roles are allocated within firms. It focuses more on responsibilities. So I would have, the way I would answer that is to say that the data governance requirements need to be attributed, somebody needs to be responsible for ensuring that there's a proper data governance policy in place and that that policy is being adhered to. It's not necessarily that that has to be a very specific named individual, as in within the regulation, but the principle of the requirements need to be allocated and designated as a responsibility for somebody within the firm. So I hope that answers that.
Yeah, no, I think that makes sense, and I think it could be done by another senior executive, like an existing role, like a compliance officer or something like that. Great, thank you very much for that. I have a couple more questions. So this one's from Ina. If an organisation is using an AI tool supplied by a third party and sourced by the overall group organisation, are both the group and the local organisation considered to be the deployer?
So anybody who's using an AI system would be a deployer, but you've absolutely highlighted that those interactions between group and local organisations, I think that's still something that we were querying with AI Office in order to kind of bring a little bit more clarity about how everything will operate within groups. So if you are a deployer if you are using the AI system, so you do have to ensure that you are satisfying the requirements of the deployer. But some of the subtleties around that question, it sounds, the question is a very, very good one because it sounds like you're already starting to think a little bit around the more granular detail of the AI Act implementation. So we would hope that there'd be a little bit more guidance there about how group and local organisation interactions will operate in practice. Something, let's just say, we're going to have to work our way through.
Absolutely. Thanks, Anne. I've one more question for you. I think that's all we have time for, but the question is, why did you say that AI systems not classified as high risk may still be considered high risk? So not classified as high risk per the AI Act. Yeah.
Yeah. So I think the AI Act obviously clearly has a risk classification system. Its objective is fundamental rights, and it's coming at it from that perspective, and has identified certain AI systems that may present a risk to fundamental rights. So for the financial service specific ones are in relation to access to public services or access to services. So that's why they have been selected. However, I think that it would be very there are other risks to the firm. So, for example, prudential risks, operation risks, there are other customer risks, etc. So I think a firm under the current risk management regulations and requirements should go through an exercise of assessing the risk of each and every AI use that it undertakes in order to ensure that the use of that AI system is not posing a risk under any other of a broad range of criteria. And we understand from an industry roundtable that I participated in with the OPA last autumn that firms are undertaking and considering a much broader range of criteria by which to assess the risk that that use of that system poses to any one of their prudential, operational, etc. Objectives. Obviously, if an AI system is classified as high risk under the AI Act, it's automatically then a high risk system for fundamental rights. But it may also be posing a risk to prudential. You know, if you get your pricing wrong, that could create a prudential risk, etc. So I think it's very important that firms don't just jump to the conclusion that, oh, this AI system isn't a high risk AI system under AI Act and therefore it's not high risk. I think that would be not a very wise move to make.
Great. Thank you, Anne. I think that's all we have time for on the questions, unfortunately. We could probably talk for a lot longer, but we'll have to stop it there due to time. So just to close, just like to thank you, Anne, for sharing those valuable insights, and then to all of you for your participation today and the thoughtful questions you posed during today's session. We hope that the webinar has increased your understanding of the evolving regulatory landscape for AI and insurance, and the practical steps obviously the firms can take to ensure responsible and effective AI adoption. Just a quick reminder before we close, both the session recording and the slides will be available in the virtual library shortly. And we hope to welcome you to the final session in this series, in the AI Insurance series. That's going to be held on the 3rd of March with Gary Layden of Instech offering an industry perspective on the use of AI. So thank you again, everyone, for joining us today, and have a great afternoon.
Thank you very much, everybody. And thanks for all the kind comments.
Thanks a lot, and that was great.
Thanks so much,
very
Anne.
good.
Thanks,
Thank you,
Fiona.
Fiona.
Well
Thanks,
done.
guys.
Well
Thanks.
done, Anne. You can see by the comments, everybody really enjoyed it, found it really insightful. And that last slide is just fantastic to give us all a reminder of the type of questions that we should be thinking about and how we can help ourselves to build that framework. So thanks, that was really brilliant slide. Thank you.
Yeah,
Brilliant.
no
Thanks a
problem.
lot, everyone.
Thanks.
Well done, Fiona. Thanks a
Bye-bye.
million.
Bye. Catch
Bye.
up soon. Bye.
Thanks.